Hi, class. Good morning, or good afternoon, or good evening. I promised both classes a recording, so I'm just consolidating them together in this one recording. Well, this will probably be broken up into several recordings because YouTube has not yet verified my videos, and therefore I have a 15-minute limit, so I will have to break it down. Okay. So, in the other class, we stopped at vague and overbroad laws. So let us start from there. Okay. Of course, you already know the case of Ople versus Torres. This is the administrative order issued during the time of Fidel Ramos, imposing the national ID system not through a law but through an administrative order. Okay. In that case, the Supreme Court said that a law that is overbroad and vague must be struck down on its face when it threatens the people's right to privacy. So, in that case, they use three important terms, no? Overbroad, vague, and then it must be struck down on its face. So, these are important concepts in constitutional law, so I would like to discuss them with you. So, let's begin with the easiest one, vague, no? Okay, a statute or act may be said to be vague when it lacks comprehensible standards that men of common intelligence must necessarily guess at its meaning and differ in its application. So the standard we use is men of common intelligence. Okay? If men of common intelligence cannot understand the law, then it must be vague. Okay? So why is it void? Why do we say that it is void? Because it violates the Constitution, particularly the provisions on due process in two ways. No, first, because it is vague, it does not advise the people. It does not tell the people, especially the parties targeted by such law, what is the prohibited conduct. Okay, and that is unfair because they prohibit a conduct, and those targeted do not understand that their conduct, that a particular conduct, is being prohibited by the law. So it is unfair and it deprives you of due process because you are not properly informed. Okay? But more important than that, because it is vague, okay, then it leaves law enforcers with unlimited discretion to interpret its provisions. And therefore, it becomes an arbitrary flexing of government muscle. That is why it is vague. That's why it violates due process. Because we cannot come up with a common understanding, law enforcers will enforce it the way they want to enforce it. Okay? Which is why it is violative of due process. In Ong versus Sandigan Bayan, he questioned here the law on forfeiture of ill-gotten wealth, claiming that it is vague. But the Supreme Court disagreed with him because men of common intelligence can understand income that is manifestly out of proportion to his lawful income. That is so clear. No? There's nothing vague about that. And therefore, the Supreme Court said the law on forfeiture of ill-gotten wealth does not violate due process. Okay? Now, what is overbreadth? According to the Supreme Court, I'm quoting the Supreme Court here. Okay? It says a governmental purpose may not be achieved by means which sweep unnecessarily broadly and thereby invade the areas of protected freedom. Okay. I think the best example for this now would be the Anti-Terrorism Act. You read the case of Calleja, you should have read it at least, no? And you will see there that several provisions were struck down for being overbroad. Okay? If you will remember in Calleja, particularly the Section 4 definition of terrorism, the authors of the bill or the law claimed that they are trying to protect the freedom of expression by expressly stating that they are not part of terrorism. But in the way it was stated, no, it appeared that you can engage in or you can exercise your right to freedom of expression, you can attend public assemblies, you can speak, you can do that. But it appears that you have to prove that it is not for purposes of terrorism. And so it became overbroad because now the burden of proof is on you to prove that this is not for the purposes as defined in the Anti-Terrorism Act. Okay, that's why it was struck down. The intention was good, but in trying to achieve, no, the governmental purpose, the state over broadly, no, threatened the freedom of expression. That's why it was struck down as overbroad. Okay? Now, facial challenge, I already discussed this in both classes, no? As I said, this is simply another kind of challenge, no? We have already learned in your first year Consti 1 as applied challenge. In facial challenge, you do not wait for the law to be applied to you. You question the law on its face. Okay? And you are allowed to do that because only if the law suppresses the freedom of expression, excuse me, the freedom of expression. And why are you allowed to do that? Wouldn't that be premature? Wouldn't there be no actual case or controversy? Well, in the case of a statute suppressing the freedom of expression, okay, the law deems the controversy is created by the fact that the mere passage of the law creates a controversy. Why does it create a controversy? Because the mere passage of the law creates a chilling effect. Okay? It cows you into submission. It scares you. Okay? And therefore, you will avoid speaking. You will avoid expressing. And because of that, no, the chilling effect, because it scares you, okay, it violates your right to freedom of expression. That is why in a facial challenge, your argument is that the mere passage of the law suppresses the right. And hence, when it is the freedom of expression, you are allowed to challenge a statute on its face. Okay? They tried to use that against the Human Securities Act, the one that preceded the Anti-Terrorism Act, no? But the Supreme Court here said that the Human Securities Act prohibited conduct, not speech, okay? Not expression. And therefore, it cannot be subjected to a facial challenge. It didn't say that it was not unconstitutional. It was just that if you want to question the constitutionality of the provisions of the Human Securities Act, then you have to wait for an actual case or controversy, because the court said there is no suppression of the freedom of expression through the Human Securities Act. Of course, iba na yan ngayon because of the Anti-Terrorism Act. No? And if you read the assigned cases in Calleja, you would know that the Supreme Court struck down several provisions that were facially challenged. Okay? In Imbong versus Ochoa, I'm citing it here only because in prior cases, the Supreme Court said facial challenge on the ground of overbreadth or void for vagueness can be done only against statutes suppressing the freedom of speech. But in Imbong versus Ochoa, the Supreme Court expanded this, no, clarified that it should be understood that facial challenge can be done if it suppresses the freedom of expression. So this will include the right to peaceably assemble, the right to petition the government for redress of grievances, the freedom of the press, and the right to free speech. No? So the broader right, freedom of expression. If a statute suppresses the freedom of expression, then you can challenge it on its face. You do not have to wait for the law to be applied because the controversy is deemed to exist the moment the right to freedom of expression is suppressed by law. Okay? I hope that is clear.